Breaking news. The Washington simple felony drug possession law has just been declared unconstitutional by the Washington Supreme Court. That's huge. It's going to affect thousands of current cases and probably tens of thousands of prior cases. My name is Lance Fryrear, and I'm the owner of a criminal defense firm in Linwood, Washington. And I have this YouTube channel to put out information about the law, and just educate people about all different types of criminal law matters. And this is such big news. I'm filming this video in my office. And so if you might hear some noise in the background, please forgive me. It's not in my normal home studio doing this. I'm trying to get the information out today. So in this video, I'm going to cover three things. One, what did the Washington State Supreme Court rule today? What is it? What happened? Number two, what might it mean for current criminal cases? And that one is fairly obvious, I think. And number three, what might it mean for people that have ever been charged or convicted of a simple felony drug possession law in Washington State? So if you find this video helpful, please please subscribe to the channel. It helps me get the information out. Otherwise, I'm just going to jump right into it. So number one, what happened today, February 25th, 2021, with the Supreme Court ruling? Well, the court issued a ruling in a case called State v. Blake, where somebody who got charged with possession of a controlled substance basically was found guilty and then appealed. And on the appeal, they argued that it was unconstitutional for Washington to have a law, a statute, the felony possession of drug law, that made it a strict liability crime to possess drugs without a prescription. And the court took a look at all the laws in the nation and pretty much found that Washington was the only such place, the only state that had a strict liability drug possession offense. From the defense point of view, the argument was they have to have what's called mens rea, or evil intent, to make something criminal, for the state to exercise their police power. And the argument from the defense was the statute doesn't require that. If the prosecution isn't required to prove knowingly possessing a drug, then that should be unconstitutional. And a bit of the defense argument in the case was, hey, they found some drugs in someone's clothes, and the argument was, I just got these clothes. I didn't even know the drugs were there. And if the statute is so broad that it makes it illegal to unknowingly possess drugs, that's unconstitutional. And guess what? The Supreme Court agreed. So that is what the court ruled today. And while most of us are probably against drugs, I think that it's fair to say that none of us would want to be convicted of possessing a controlled substance without knowing we ever even had the controlled substance on our person. That really doesn't seem fair, and it's pretty much a nightmare. And so that's what happened today. So number two, what does this mean for currently charged simple possession cases? Well, we would expect that currently charged simple possession cases will be dismissed. We would expect that people being held in jail only on a simple possession charge would likely have a good chance of being released. We would expect if there's currently a trial set for one of these cases, that a prosecutor would likely have to dismiss the case unless they could amend the charge to something else. Again, this is for simple possession of felony drugs. Think about it's called VUSCA, V-U-S-C-A. You may have heard of that. Violation of the Uniform Controlled Substances Act. And it only applies to a certain section, but it's a very broad section because it's a common charge. So most importantly, number three, what might affect more people is, well, people that have ever been convicted of this type of charge might be able to get it removed from their record. If you've ever been sentenced on another charge that used a prior VUSCA conviction to enhance your sentence, to affect your points, you might be able to be resentenced. Additionally, I could imagine a situation where if you were convicted of this type of drug charge and you lost your firearm rights because of it, you might be able to get your firearm rights back. And so this is brand new. It just came out today. So we're still looking into it and learning about it. So if you have questions about this, or you think you might be in one of the categories of people that might be able to get relief based upon this new law, you can give our office a call. My name is Lance Fryrear again. I'm the owner of the law offices of Lance Fryrear. We've been defending people charged with crimes for more than 20 years. We're a 5-attorney firm in Linwood. We're here to listen. We're here to help. We'll do what we can. and we'll be there for you.